lucky to have as a resource the great talent, the great minds at the University of Illinois. And joining us now from the University of Illinois, Edwin M. Adams, professor of law, director in the program at criminal law and procedure. It's Andrew Leopold to try to help us with this cash bail story that, frankly, a lot of us probably wondered where it ended up and what was happening with it. Andrew or Andy, what do you prefer?
Either one.
All right. You can tell he's a lawyer because he's very careful with the amount of words
you
he's
go
using.
with Andrew, I'll go with Andy.
All right. Andrew.
Works for me.
Andrew, all right, let's do some basics here. First off, we all start this, we got bombarded, as you know, during the fall and prior to last year's election with criminals will be on the street January 1st. What happened and why are we talking about this now?
Because the Illinois Supreme Court yesterday decided that the elimination of cash bail, not the elimination of bail, not the elimination of pretrial detention, but the elimination of the cash part of it was constitutional. The Illinois legislature passed this as part of the so-called Safety Act, and for a time, lower court had said it was unconstitutional, and yesterday the Supreme Court said, nope, it's constitutional. The state is now free to eliminate cash as part of the pretrial release decision.
And the proponents of this push for this, why?
Because the argument is that whether or not you're going to show up at trial, which is, of course, the primary reason behind the bail decision, doesn't turn on how much money you have. Now, it is true that if you lose money, if you don't show up, that gives you some incentive to appear. But the arguments, the ones that prevailed, were that too many people were being detained, being held in jail pending trial, not because they were a flight risk, not because they were dangerous, but because they were poor. And too many people sitting in jail for too long based on that didn't seem like a fair process.
And the flip side of this, on the argument was, well, where does it stop? Because we saw commercials that said murderers and thugs and all sorts of horrible criminals would be let out on the street. Do judges have some dexterity in this, some latitude to make sure that doesn't happen?
Judges have dexterity and latitude. They had it before. They have it now. Judges are free to detain not anyone, but anyone who is accused of committing a forcible felony and even a lot of non-forcible felonies, all violent crimes basically, to detain them because they create or pose, to use the language of the law, real and present threat, either to the community as a whole or to some individual. So, yeah, judges still have the authority to detain people if they think create a risk to public safety prior to trial, just as they did before.
So it's not a 100% get-out-of-jail-free card, but you keep leaning on the word, it's not a cash bail, but there can still be bail. Would come in a different shape or form.
Well, there are always conditions imposed on people who are released prior to trial. But people often think of bail as being interchangeable with cash bail, right? Money. You post some money in order to make sure that you show up. If you think of it just as the pretrial release decision, judges are now, as they've always been, free to impose conditions on people. You have to stay, you can't travel out of state. You have to surrender your passport. You have to comply with a certain curfew. There's all sorts of conditions. You have to stay away from the people involved in the crime. There's all sorts of conditions you can impose on people, and those are bail conditions. It's just the money part is now gone.
All right, so trying to take the politics out of this, which, as you know, Andrew, is very difficult in the world we live in now. Is this a good thing or a bad thing in the eyes of the law?
Well, I don't know what in the eyes of the law means exactly. This is what the Illinois legislature, the people's representatives, have passed. Whether it will be successful or unsuccessful remains to be seen, right? I mean, Illinois is the first state to have done this. There have been individual jurisdictions that have tried this in a more limited way, but the elimination of cash bail will have some predictable effects. It will lead to more people being released prior to trial. I don't think there's any dispute about that. Surely, some of the people who are released prior to trial will commit further crimes. That's true now. The question is, are we striking the right balance between being fair to people who are no risk to flee, who are in jail only because they can't afford the bail amount? Is that benefit that we're getting worth whatever cost? And nobody, let's be clear, nobody really knows the costs that are going to be imposed. It's just because we haven't done this before.
Understandable. Let me see if I can ask it in a better way, because it was confusing the way I put it. What I'm looking for, I suppose, is this. We live in a cynical time, and the belief is that if we leave the latitude up to judges have different viewpoints on different things. There's a backlog of court cases everywhere. They need to move things along. Nobody wants to be a part of a social experiment when it comes down to bad guys. Are the guardrails strong enough here, or does that also remain to be seen?
Well, it remains to be seen, because there's no right or wrong to this. This is a judgment that we're making, right? We release lots of people prior to trial now with cash bail, and some of those people commit crimes while they're out on bail. And the only logical place would be to say there is no pretrial release. Nobody gets bail. Everyone stays in jail, or everybody gets out. Neither one of those is realistic or desirable by any in any sense of the word. And so the question is, we got to draw a line. How do we draw the line? Do we make cash part of that? And which people do we let out? And which? It's an imperfect science, and there are going to be mistakes, and not even mistakes. They're just things we don't know. It's a volume business, and judges are working with limited information. We do the best we can, but at some point we got to draw lines, and if it doesn't work, unfortunately there'll be costs associated when things don't work. There always is, but they'll return, as it sounds like the legislature is still talking about tinkering with the contours of the act. So we're not done with this yet.
Yeah, and it's happening in other states as well around the country. We just happen to be the first. Is September 18th, is that the date where this goes into play?
I think that's right. I think that's what the court said. The 18th sounds right.
Okay. So we appreciate your information.
Yeah.
We'll come back for another class. You do great on the curve, right?
I do.
Okay, thank God for that. It's Andrew Leopold, professor at the University of Illinois. Thank you very much. I don't know if I feel any better.
No, it's good insight.
But
it
is good insight.
Yeah.
And my concern was kind of based in my question, and that is when judges have latitude,
sure,
and we have the backup we have,
right,
are mistakes going to be made, or are there going to be leniency where there shouldn't be?
And then when I would say to that is that we have to hope that the judges instill proper bail conditions, or don't release the people that are violent criminals or going to continue to commit these terrible crimes.
Nick, what if we did this? What if we said anybody who's committed a felony, if a judge does say it's okay to release them, they have to spend 10 days with the judge first. They actually go home with the judge.
That could be one of the bail conditions.
Mm-hmm. Let me see if I can get that done.